And our second case this morning is number 20-2511, Curtis Andrew Long versus the State of Florida.
Good morning, Your Honors. May it please the Court. My name is William Pinnell, and I represent Curtis Long, the appellant in this case. Please reserve 5 minutes of my time for rebuttal. Okay. It's our position that there was 2 fatal flaws in this case, that the trial attorney at sentencing and at the failed to expose, object, or argue to. First, that the state failed to meet its burden to show that the failure to appear at sentencing in this case was willful, and second, that the trial counsel failed to object to the trial court's failure to make a finding that it was willful. The case law from this court and throughout Florida clearly establishes that the state has the burden to show that a failure to appear is willful, and the trial court must make a finding that the failure to appear is willful before increasing a defendant's sentence pursuant to a Quarterman agreement. In this case, we have the defendant entering a plea to an agreed-upon sentence of 15 years in prison, but he's released pending sentencing. He fails to appear at sentencing on January 18th. He's arrested for the failure to appear and for alleged grand theft on the 19th of January 2016, and then when he returns for resentencing, he is given a 30-year sentence, 2 times the sentence he agreed upon.
Well, at one of the hearings, the defendant stated that he was a drug addict, he was on drugs, and he had children, and those were the reasons he gave for not appearing. And then his attorney testified that he told him that the reason he didn't appear was because he was on drugs. He was on the run, and you know, he just didn't make the hearing. He had children he had to support and that sort of thing. So what is the attorney supposed to do? I mean, taking drugs and having children to support and being on the run indicates to me that he willfully failed to appear. I mean, what else is the attorney supposed to present if the defendant doesn't give him any other information as to why he didn't appear, and there's no other evidence as to why he didn't appear? What is the attorney supposed to do?
So it's our position, if you read the transcript from the sentencing, I agree with you that the defendant made those statements, and that was kind of an allocution statement after the defense lawyer was making the legal argument. It's our position that before the defendant even made his statement, as part of the legal argument, the trial lawyer should have argued the state's evidence didn't establish a willful violation. The trial counsel doesn't have an affirmative duty to establish that it wasn't willful. The state has to prove that it was not willful.
But there's no doubt that he was told when he was supposed to reappear for sentencing. And that, there's no dispute about that, is there? He was advised about that. He knew about that. He knew the date and when he was supposed to come back. And his excuse for not coming back was, I'm a drug addict, I was on drugs, I had children to support, and I was on the run.
I agree with that.
And he doesn't appear, so how is that not willful?
So I think this is an equivalent to a JOA situation before a defendant testifies. The state has the burden, in a regular criminal case, the state has the burden of proving the case beyond a reasonable doubt. Before the defense puts on a case, the case could be dismissed because the state didn't prove the case. Here, trial counsel acknowledges that the state has the burden, the case law establishes the state has the burden to produce affirmative evidence of a willful violation. If you look at the Robinson case from the second DCA, they talk about the defendant signed a plea form, he was told that he had to be there, and he didn't show up. And they said that alone is not enough. The state has to present affirmative evidence that it was a willful violation.
What else does the state need to present if the defendant says, I didn't show up because I'm a drug addict, I was on drugs, I had children's support, I'm on the run? What else are they supposed to present? I mean, that's enough, isn't it? Why isn't that enough? I guess that's my question.
But my position is, and I think the case law supports this, the state didn't present that evidence. I think this is important. I think there's an important distinction between what the
Yeah, but
defendant said.
These are statements that the defendant himself made on the record, and his attorney testified that this is what he told him.
I understand. That.
You're arguing timing, right? In other words,
Yes.
the state put on its case, and you're
Correct.
saying at that point, at the end of the state's case, they hadn't offered proof of willfulness.
Correct.
And right then and there, he should have been home free in terms of the Quarterman issue and just
Correct,
back to his 15 years.
Correct, Your Honor.
That's your argument. isn't it?
That is my argument, and if you read the transcript, trial counsel is making his legal argument as to why there wasn't a violation before the defendant testifies, and then the defendant kind of jumps up and says, I want to say something. But it's our position that trial counsel was deficient here because at that point, he should have argued that the state didn't make their affirmative showing of willfulness. The evidence of willfulness...
How does the state prove willfulness other than, and I guess perhaps that's what my colleague here is getting at, he knew when he was supposed to be there to the nth degree, and he had been warned, you better show up or else you're really going to be in trouble here. You get a lot more time than if you fail to show up. What do? They have to read his mind?
I think there's a couple ways they could do it. I think it's a good question. I think certainly when he was arrested on the warrant, if they had a custodial interview with him and he said to the officer, yeah, I knew sentencing was that day, but I wasn't going there because I didn't want to go to prison. That would certainly be evidence it was willful. Let's say he showed up a half an hour before court and a bailiff saw him and the bailiff said, Mr. Long, your hearing starts at 9, you need to be here, and then the bailiff sees him leave. That would be evidence of willfulness. What we know is not evidence of willfulness or sufficient evidence of willfulness is just the plea agreement and the admonition at the hearing, and that's what the Robinson case says. So you're correct, the timing is important, and the state has to present affirmative evidence separate from the defendant's evidence to support a finding of willfulness. And that's
What about the length of time that expired between the time of the plea, the time of the sentencing, and the time that, he didn't turn himself in, ultimately, correct? He was picked up on a warrant for another charge,
correct.
right? He wasn't turning himself in. He didn't suddenly come to some clarity when he ceased to be under the influence of drugs where he turned himself in.
So
11 days expire.
Correct.
He still hasn't turned himself in. He was fully notified based upon the Quarterman release that he needed to be in court at that time. Otherwise, he was facing an alternative sentence, for lack of a better term.
So I'd ask the court to look at the Robinson case. In that case, he failed to appear at a February 24th sentencing hearing, and then he was arrested on a no bond capias in May. So March, April, 3 months later. And then he was sentenced in violation of for violating the Quarterman agreement to a 5-year prison sentence instead of the 6-month county jail. And they talk about, again, that they say nothing in the record establishes that his failure to arrive was willful. So even with a 3-month time lapse. So we don't know. The state has the burden. The only evidence they put on at the sentencing hearing was related to the grand theft, which ultimately the victim of the grand theft said there was no grand theft, that his brother lent him the motorcycle. So there was no evidence explaining why he didn't show up. I know it's counterintuitive and it seems difficult to
There was
prove.
evidence that he was clearly informed that he needed to show up when it was time to report to start serving his sentence, correct? There's
100%.
no dispute as to that. As to the first case, correct?
100%.
Okay.
The Robinson court says that doesn't
So
matter.
the day after, 24 hours after the 8th of January, he was aware that he should have been in court 24 hours ago, correct? Or is your position that he was unable to willfully not appear because he was under the influence of drugs and he was on the run?
My position is that there's a failure of proof here, not that I don't know why he didn't appear, and there's nothing in the record explaining he wouldn't appear except for his statements.
Your position is that his statement said, you know, I'm a drug addict, I was on drugs, I had children to support, and I was on the run. It should not be considered at all by this court, or shouldn't have been considered by the trial.
I think his trial lawyer made a mistake by not arguing that the state failed to meet their burden of proof before allowing the defendant to give a statement. The trial lawyer was making arguments and made arguments at the sentencing hearing regarding why they didn't prove the grand theft to be a violation of the
Well,
court of...
when did the defendant made the statement that, you know, I'm a drug addict, I was on drugs, and I have children to support at a hearing? That hearing was before the final hearing in this case where he was sentenced. Isn't that correct? When did he make those statements?
It was at the sentencing hearing where he was sentenced to the 30 years.
It was at the sentencing hearing when he was sentenced for the Quartermain violation?
Yes. So we have on page 473 of the record, at the top of the page, Mr. Long's trial counsel arguing that they didn't prove the grand theft, and I think everybody would agree with that because the victim even himself admitted that the motorcycle was not stolen. And then the trial lawyer says, as to the failure to appear, the evidence is there. The court has the record. Mr. Long was not present at the time that he was supposed to be present for his sentencing on January 8th. And he concludes his argument, and then the defendant testifies. The ineffectiveness is failing to argue at that time that the state failed to meet its burden of proof to show that it was willful. Not that some later statement by the defendant may have shown it was willful. Whether the state met their burden of proof.
So you're saying that that's untimely evidence. It shouldn't have been considered because the state didn't meet its burden before.
I'm saying that trial counsel was ineffective by not arguing before that evidence was admitted.
I got you.
That the state failed to meet their burden. And if you look at the
In Robinson, the guy said he had a flat tire. He called his lawyer. He was going to be late for the hearing, and also said that he had no idea that his sentence could be increased if he missed his hearing. There is no evidence in Robinson of I'm on drugs, this, that, and the other. It doesn't say at what point in time. You know, again, proving willfulness, I agree with the examples you gave, could prove willfulness. But if the guy says nothing, if the guy never shows up at court, you're basically saying can't prove willfulness.
We may not like it, we may think it doesn't sound right. That's what the law is. The state has the burden to prove the negative. That's the law. And in Robinson, the defendant signed a written plea form saying, I understand if I fail to timely appear for my pre-sentence investigation or sentencing that my plea will stand, but the sentence agreement is void, and I may then receive the maximum sentence authorized by law.
Right, but he claimed he didn't really understand that, and again, in reality, we all sign a lot of papers that we, under the circumstances, may or may not fully appreciate. You're still bound by it, I get that, and I'm not suggesting to anybody listening in that you're not. But, you know, he's claiming all these things. I had a flat tire, I called my lawyer, Robinson, I called my lawyer, I had a flat tire, and the judge still goes, too bad, pal, you're going away. I mean, that's a completely different circumstance here than what we have. And again, I understand your argument is timing. The state didn't prove it.
Certainly if the state introduced the defendant's testimony, let's say he made those statements to an officer in a custodial interrogation, and they introduced that evidence, I would agree that they'd prove willfulness, 100%. The point is here, at the time the lawyer's making the argument, the state did not prove willfulness. And I think it's important, I want the court to look at footnote 2 in the Igmeyer case. And they talk about, before the footnote, they talk about how the state didn't meet their burden, and then they talk about the only evidence to suggest that there was willfulness came from the defendant, and they still say that that wasn't sufficient. So again, it's like a JOA at a trial scenario. You don't get to the defendant's testimony if the state didn't meet their burden. And that's where trial counsel failed here, by failing to argue that the state failed to meet their burden, because the only evidence they put on was evidence related to the grand theft, which was then refuted by the victim himself. So we'd ask the court to reverse, and with instructions that the 15-year sentence be reinstated. I'd reserve the rest of my time for rebuttal.
All right, thank you.
May it please the court, my name is Richard Pallas. I represent the state of Florida. And it's our position that the trial court properly denied this Rule 3850 motion. The defendant talks about timing here and how this is akin to a JOA. When on appeal it's determined that evidence wasn't sufficient to go past the JOA, it's clear in all case law, you go back and that charge is vacated. The conviction goes, sentence goes. That's not how this court in both Speer and Richardson has warranted how we handle when willfulness is not established. In those cases where willfulness was not made as a finding on the record, they instead remand to have the hearing. And then the state may present its evidence, meet its preponderance of the evidence burden. And going off of all of this timing, the defendant was looking at a lot of time here. He was looking at 70 years after violating this Quarterman's agreement. To say counsel was ineffective for not saying, hold on, Your Honor, the state never met its burden and you never made your finding of willfulness, so we can't go here and you have to sentence him to the 15 years followed by 5. Our standard isn't that, or how should I say, this isn't just some revisionist history that just changes the record. The trial court's going to do nothing, and then the appeal goes the other way, and the defendant succeeds with, I believe it was his petition alleging ineffectiveness of appellate counsel, stating that the willfulness wasn't made. Instead, the trial court is going to make its finding. The state asked it to take judicial notice of the failure to appear and the plea agreement. The trial judge knew how much time had passed. While, of course, this finding wasn't based upon the new criminal charge, instead, we have nothing but testimony showing defendant's been riding around Brevard County on a motorcycle. I don't know its willfulness of not showing up to court, not contacting the court, but instead contacting the man who didn't know that his brother loaned you his bicycle. All that in mind, again, the standard for Strickland with prejudice is not that things would have been different on appeal, it's that things would have been different at the trial. And because of all that, I believe that the trial court would have had what it needed to make this finding. And everything procedurally here is a nullity, because after the trial court says, well, I did make my finding, would you like to rebut that by responding with, well, he's on the run, he's high and he's suicidal. That's not going to get it done. The trial court's going to find the willfulness and possibly sentence this defendant to something higher than 30
Opposing
years.
counsel says that testimony or those statements from the defendant shouldn't have been considered in resolving these issues. You agree with that?
Well, Your Honor, if we are speaking procedurally here,
And he said that I'm a drug addict, I have children, I'm on the run, and that sort of thing. But opposing counsel says that should not have been considered, should not be considered in resolving these particular issues. Do you agree with that?
yes, Your Honor, very limited low. I only agreed with that to the extent that if we were only looking at this by procedural and nothing was shown by the state supporting that this was willful, then perhaps the defense has something there. But instead, typically when the state has met its burden by preponderance of the evidence and the trial court's ready to make its finding, the defendant doesn't have to stand pat and say, darn it, the state's got me. The defendant is able to bring forth his own evidence. I mean, here the state concentrated most of its evidence on the new law charge. But that evidence from the new law charge, in part with the judicial notice of the failure to appear, and then the plea agreement itself, I believe is enough for the trial court to make this finding. So the preponderance of the evidence was met. This objection would be meritless. But if the court then made that finding, it would say, well, what do you have for me? Because maybe you can bring me below this preponderance of the evidence standard. Saying, my phone died, my ride fell through and he couldn't call me, that may help. But that's not what he told counsel. And competent substantial evidence supports that counsel was not told this, because obviously the statements that he was told of being on the run, high on drugs, suicidal, all of that is corroborated by how the defendant pled for mercy to the court when he was stating why he didn't show up in the first place and why he shouldn't be sentenced to more than the agreed upon plea agreement. And
So, counsel, you believe that the grand theft charge was a significant element to proving willfulness as the failure to appear at the quarterman?
no, Your Honor, I don't believe it was a significant element. I just believe that portions of that help fill in the blanks here.
How so?
I believe that the fact that we have the defendant, there was talk of the text messages between him and the alleged victim in that particular grand theft crime. And the alleged victim stated that he was telling me his situation. And of course, we just, I believe almost circumstantially, the defendant's.
When you say telling the situation revolving around the grand theft, or the situation involving his status as being on the run with a warrant out for his arrest?
That's what I'm more inferring, Your Honor.
And the warrant as far as the failure to appear at the sentencing?
That's correct, Your Honor.
And was that developed clearly with the trial court?
It was certainly not stated verbatim like that. No, Your Honor. The state was certainly arguing more along the lines of the failure to appear and that he was arrested based on that and not turning himself in voluntarily. And, well, of course, being arrested on that after being arrested for the grand theft and then being served the warrant for the failure to appear. And then, of course, that this was a very detailed plea agreement. We had a very detailed plea colloquy here. The defendant knew where he was supposed to be at 10 a.m., and he wasn't there.
In your position, is it enough to show willfulness, to show that he was specifically advised as when he was supposed to come back, he knew the date and time, he didn't appear, and while he is failed to appear, commits another crime, finally arrested and brought in. Do you think that that is enough to show willfulness?
Well, no, Your Honor, to the extent that, of course, he did not commit a crime because the court did not find.
Well, that he was charged or accused, right? He was while he was out.
Yes, Your Honor.
Charged, or at least maybe he was arrested for that. There was a warrant for his arrest. Do you think that's enough to establish willfulness?
I do, Your Honor. Yes. I believe that that's enough to establish the willfulness. And in the event.
Take out what if you extract from that calculation the charge that he was arrested for the new offense? You just have, he was given the date, he knew the date and time, that's clear on the record. He didn't appear, and he was finally picked up.
Well, Your Honor, I believe that would not be enough on its own. But of course, that's not what we have here. Here instead, we have, as we said, the evidence from the previous hypothetical that we discussed. But again, going based off all our prejudice here is the fact that things would have been different. It's observed in, I believe, one of the defendant's cases, Cruz, that sometimes, of course, you may not want to argue willfulness. You might want to rely upon mercy instead. Here, that was clearly the better way to go. He could have gotten 70 years. He only came out with 30. It's not what he wanted. But to the state, that's more than enough here. And again, the prejudice here component, it wouldn't, even if defendant was entitled to relief, it wouldn't result in us gifting him a 15-year sentence followed by 5 years probation. It would be to just have this hearing. But if this court has no other questions, I will rely on the state's brief, and I ask that you affirm.
Okay, thank you.
May it please the court. The pertinent issue here is that the state has to prove willfulness by affirmative evidence, not through the defense's case. So Igmeyer, 2nd DCA 2009, where they found that the evidence was insufficient to establish that the defendant willfully failed to appear for sentencing. On page 3 of the opinion, in the second to last paragraph, there is an absence of positive evidence to establish willfulness. So you need affirmative evidence from the state to show willfulness. We don't have that
Aren't they talking
here.
about competent substantial evidence here and taking into consideration what he said, that he had misread the date? As soon as he found out, he turned himself into the bail bondsman and all the rest of that? I mean, it's, right? That's the Ingmeyer case, or am I thinking of something different?
No, they talk about the state's failure of evidence.
No, I'm talking about the facts of the case and what they're looking at. I mean, this is a case in which the defendant said he misread the date, whether it was on the court papers, on his bail bond, whatever. He misread the date, and that's why he didn't show up. As soon as he found out about it, he went to the bail bondsman. He said he went to the courthouse and talked to a bailiff, whether or not they really discussed it. But I mean, it's different. And if those facts didn't matter, why is the 2nd DCA talking about them?
I think they're just giving a full account of what happened, but
If the only question is the state has to prove it, why didn't the 2nd DCA stop right there? They didn't prove it, we're done. Instead of, by the way, this guy had a really good excuse. He misread the date, human error. He quickly took whatever steps he thought he could take. That's not our case.
certainly, but the law is the law, and it says the state has the burden, and remains our position that through the 2 witnesses they presented at the sentencing hearing, they didn't show that this was a willful violation of the plea agreement. The Robinson case makes it clear that simply being advised of the date, signing a plea agreement saying you understand you have to be there, that's not enough. There has to be additional positive evidence. So, yeah, the Igmeyer client may be more sympathetic. His story might sound believable and may justify what he did. But here, when the state rested their case, they didn't prove willfulness. And the
State is now suggesting that the remedy, if we agree with you on that, would be to remand for another hearing. Do you think that's appropriate?
I do not. and I think-
I know your answer is no, so tell me why not.
Sure. In the Richardson case, which the state cites for that purpose, the trial court, after the defendant appeared for sentencing, the trial court sentenced Richardson in absentia, imposed the prison term, and there was no actual hearing where the state had to prove willfulness. So there was never a hearing. Here, the state had their chance. They don't get a second bite at the apple. They had their burden of proof, and they didn't meet it. They rested their case. That's the evidence they chose to submit, so it's different than the Richardson case. As to prejudice, the state argues, well, the judge was going to find willfulness nonetheless. Strickland on page 695 of the opinion says, we have to assume in the 3850 context that the trial judge presiding over the case would have applied the applicable law. Not that the judge would have got it wrong. It doesn't depend on the specific judge. We assume it's a reasonable judge who applies the law. The law is that the state has to present positive affirmative evidence showing that it was a willful failure to appear. They didn't do it. Had the trial counsel made that motion and said, Judge, they didn't prove their case, under the law, the judge would have been required to say, you haven't shown a failure to appear, willful failure to appear. He can only be sentenced to 15 years according to the agreement. That's the Strickland prejudice here. That the trial counsel didn't make the argument that the law required the state to meet their burden, and the state did not meet their burden. So the correct result here is to grant the rule, to reverse the denial of the 3850, and with remand for instructions that the 15-year sentence be imposed. I'd ask the court to reverse and impose that remedy.
All right, thank you very much. And we will now be in recess.